Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and I hope you're having a great day. For today's video, we're going to be analyzing in a little bit more depth the Kowalski verdict. This is something we've talked about a little bit before, but I wanted to give it a bit of a deeper dive and talk about it a little bit more in depth, with particular attention to how the Court of Appeals will think about this and what the role of a juror is, at least as far as the law is concerned. So this isn't necessarily just my opinion of the thing, by the way, because the court in its instructions makes clear that the role of the jury is to follow the court's instructions, and they're to follow what the court sets out. The jury is not here to just do whatever they want in some sort of vague sense of trying to accomplish justice. They're not here to just apply things in some sort of equitable fairness kind of way. The jury's role is to find facts, and their role is to find facts with respect to particular questions, the questions that are asked them. And if the jury goes past that, if they do more than that, the jury violates their role. The jury disobeys the law. The jury abuses their power. So the proper role of the jury is to apply the instructions the court gives them and to answer the questions the verdict forms asks for as they're written. They're not just to do whatever they want. So I want to go over this with a little bit more detail to try to discuss some of these issues. And this is partially also to discuss some of the issues that were mentioned last night on Nick Ricada's stream by one of our non-lawyer participants during the stream. This participant, who is not a lawyer, suggested that this verdict was good because it was a wake-up call to hospitals everywhere who collectively, at least in their judgment, have done many, many things wrong. And this verdict is, in some sense, at least as I heard it, meant to remediate the broader issues in the world. And as I was trying to explain, but not being heard, that is not the proper role of this jury. This jury's role is merely to try to solve the harms that did or did not occur to Maya Kowalski. They are not here to solve any other harms that Johns Hopkins Hospital did to anyone else, nor are they here to try to solve what other hospitals may or may not have done with respect to any cases that you would care to illustrate, right? Those people, to the extent that they have causes of action that are valid, should and hopefully will receive justice in their own cases. That's a role for their juries to do in their particular cases. This jury is not here to try to send some sort of message to all the hospitals everywhere who collectively, for the sake of argument, have done many, many bad things. They're not even here to punish Johns Hopkins All Children's Hospital for its many sins. They are here specifically and only to solve the problems for Maya Kowalski. Has Maya Kowalski been injured? And if so, does she deserve compensation? And how much? With particular attention to the specific causes of action, what they are, and keeping them within their own domains. Making sure that we are assessing each cause of action, each count with the particularity the question is asked. And that is the proper role of the jury and what the Court of Appeals will be looking to, at least in part, right? Did the jury extend beyond their province by, for example, not answering the question they were asked? They can only answer the question they were asked and nothing more. Did they do that or not? And that's one of the things that they're meant to do. So I thought we could read this jury questionnaire again with particular attention to the specific causes of action and seeing exactly what the jury is being asked and see whether or not their verdict makes sense, not with respect to all harms that hospitals have caused everywhere, not with respect to all harms Johns Hopkins has caused all of its patients, not even with respect to all causes that they did to Maya Kowalski, but with specific attention to the specific causes of action in their specificity and in their detail, and making sure we stay within the proper domain of each individual question and we don't cross pollute. This is the proper role of the jury. So let's read it with a little bit of precision, because the jury was supposed to read it with precision. They were instructed to read it with precision. So let us also read it with precision and see whether or not we feel they did what they were asked to do. Okay, great. So we are in the case of Jack Kowalski, individually as next friend to Maya Kowalski and as representative of his wife versus Johns Hopkins. And the jury is asked a whole bunch of very specific questions. So we're going to read these questions with the specificity they were asked and try to describe what the jury was supposed to do and also describe whether or not we feel like they did it. Okay, great. All right, so let's do that. First cause of action is for false imprisonment. What is false imprisonment? False imprisonment at its core is the civil version of kidnapping. Like many civil versions, we give it a different name. It's not exactly the same, but close enough, right? It is when you forbid someone from leaving. That's false imprisonment, unlawful restraint, unlawful detention, refusing to allow them to leave. That is what false imprisonment is. So we need to ask the false imprisonment question and ask what damages, if any, occurred from the false imprisonment itself. That is to say, the failure to allow her to leave. That's it, right? Nothing else, just that. Maya Kowalski might have been harmed in other ways. We'll get there on other counts and other claims. But for the moment, the only question we're asking is, was she kept unlawfully detained? And if so, what damage occurred from the unlawful detention itself? That's it. Great. Let's do that. So, question number one. We're dealing with the period of October 7th to October 13th. This is the initial period that Johns Hopkins was treating Maya. This is when they first encounter Maya. This is a period when Johns Hopkins was acting without any court order, and her parents wanted her to be discharged. And the hospital apparently said no, and they can't do that. Maya Kowalski at the time was in stable condition. It's not like, she was in the middle of an operation and, she was being surgically worked on, and the parents said, we want you to discharge her right now. In which case the hospital would very justly be able to say, no, right now it's not so good for us because, we're kind of right in the middle of something right now, and discharging her right now would be a really bad idea, right? So she's in stable condition. There's no medical necessity to keep her there. They just want to keep her there because they have suspicions, which even if true, they still wouldn't be able to just keep her there. That's not their role. They can't act without a court order. They can't unlawfully restrain someone. So for me, this cause of action is really simple. The jury found that she wanted to leave. Her parents wanted her to leave, and they didn't let her leave. So that's false imprisonment. So that one's pretty easy. So I think the jury gets this one right without, breaking a sweat. I think the jury could have found the other way, but there's more than sufficient information to find this by preponderance of the evidence, which is all that's required. So it works for me. So question 2, what is the total amount of Maya Kowalski's damages for medical and psychological expenses to be incurred in the future after she reaches age 18 based on the false imprisonment occurring between October 7th and October 13th, right? Just that, only that. What do we think? And the jury says $2.5 million. I think this amount is perfectly reasonable because I don't really think there's any medical expense to Maya Kowalski from the false imprisonment, right? The false imprisonment didn't in and of itself harm her physically. Medical malpractice might have, the battery might have, but we're not dealing with that right now. We're dealing with the false imprisonment during this particular period. So did this particular period cause medical problems in and of itself? No, probably not. Did it cause psychological? Yeah, I think that's fair. Because, you know, if you're falsely held against your will, that will mess with you. So I think saying that she needs $2.5 million of, let's call it psychological expense, after she reaches 18 from a result of this 6-day period is a reasonable number. So I have no particular problems with that. In question 3, what is the total amount of Maya Kowalski's damage for pain and suffering, mental anguish, inconvenience, and loss of capacity for the enjoyment of life, sustained in the past and to be sustained in the future, based on the false imprisonment occurring between October 7th and October 13th. So again, just that time period, nothing more. You know, and this is more in the nature of what harm did it cause her in the moment. Question 2 is more in the nature of what does she need in the future. Question 3 is more in the nature of what harm did it cause her at the time it was occurring. And $3 million is fairly reasonable, you know, as she's dealing with that. So I have no particular problems with that. So that's fine by me. Question 4, what is the reasonable value or expense of hospitalization and medical, psychological, nursing care treatment necessary or reasonably obtained by Maya's father for her child in the past or to be obtained until she reaches 18 for this false imprisonment? $67,000. That sounds fine to me. I have no problems with that. And then they say that we also want to find punitive damages, and I believe ultimately award $10 million in punitives, which is perfectly in line with the compensatory damages they awarded there. So I don't see any particular problems for cause number 1. This seems fine. Question number 2. Did Johns Hopkins falsely imprison Maya Kowalski during the period of October 18th to October 20th? This is the period when she's kept in the video observation room, the so-called dungeon, which, you know, okay. Did they falsely imprison her during this period? I don't think so, to be honest. I believe at this point, they had a court order in place, and the observation room, like, I don't know there's anything particular about it, but I don't also think the Court of Appeals is likely to reverse. So I'm not sure I'd vote yes, but also I'm not sure as a Court of Appeals I could reverse on this ground, because, right, it's not, the Court of Appeals' view is like, is this legally sustainable? So is it legally sustainable? Yeah, maybe. But I'll raise the question mark at least, but I think they'll keep it. All right, so what is the total amount of medical and psychological expense to be incurred from this false imprisonment for this period when she's in this video observation room? $1.4 million, we'll call it. Again, I note the typo in there, which may be an issue. I mean, it's something someone's going to argue over. They did verbally ask the jury to verify the award, and they said yes, so that probably gets them past the problem. But if, you know, someone's going to ask about it at some point, so, you know, okay, there's a typo there. But yeah, that seems fine. And what is the total amount of pain and suffering, mental anguish, and loss of capacity sustained for this 48-hour period? $3 million. Again, that seems pretty fine. And again, the punitives for this entire cause of action is $10 million, which is justified by these numbers, so that's fine. And was the total amount of care that was resulting from this $561,000, which I believe was the bill from Johns Hopkins. So that seems pretty reasonable, although that's their entire bill, so I'm not sure, strictly speaking, it's for that period, but, you know, it's fine. And what punitive damages? Do we want punitive damages? Yeah. Yeah. How can it be imprisonment if she's under a court order? The idea would at least be in principle that the court, that extends beyond the scope of the court order. They did things beyond the scope of the court order, would be the reasons. So you'd have to look to exactly what the order was and what was not. And I believe the hospital violated terms of the court order, for example, by denying her the ability to talk to her mother twice a week or something like that, which I believe they didn't do. So they went beyond the scope of the court order, would be part of the reason. So you know, so they exceeded the bounds of the court order would be the problem. So just because they have a court order doesn't necessarily mean everything they did was compliant with the court order, because they got to follow the details too, just like the jury does, right? They got to follow the details too. So I think, I'll raise the question mark in my mind, whether or not it's severe enough, but I think there's enough for a reasonable jury to do it. And I think it's unlikely the Court of Appeals will reverse. So they went beyond the court order, so they have problems. Okay, fair enough. What about the court order being obtained under false pretense? No, I don't think that works. Because the court order is the court order. I don't really think that works. You'd have to basically prove perjury, and that's tough. That's a tough sell. So I don't think so, but okay. And I'm not really sure the jury's in a position to do that. Yeah, that seems okay. Let's move past. All right. Now we get into this false imprisonment on January the 6th. This, I believe, is the date Maya is photographed on January the 6th. But we are here just on the false imprisonment claim, not the battery claim. The battery claim we'll get to in a second. So I think the false imprisonment itself, as distinct from the battery, is a little bit of a thing. What is the total amount of damages to be incurred after you reach is 18 based on the false imprisonment? $188,000. I note here that this number seems slightly odd just by comparison, because it seems like a slightly odd number, because we say $188,000 for this one day, but we also said up here $1.4 million for this 48-hour period, which is about $700,000 a day. So I'm not sure what that's about. And also we set up here a $2.5 million for this 6-day period. So these numbers seem a little arbitrary, but they're all, I think, within the bounds of a reasonable jury. So I don't think that the disparity between them is a basis. I just simply note it, that there's potentially some inconsistency. I don't think it's enough for the Court of Appeals to do about, but if I was representing Johns Hopkins, I'd probably be bringing it up. So I bring it up with you just because it might be something that's worthy of note. And then they say, what is the total amount of Maya Kowalski's damage for pain and suffering, mental anguish, inconvenience, and loss of capacity for the false imprisonment occurring January 6th? $15 million. I could see the Court of Appeals potentially lowering this amount. Again, it's just for the false imprisonment and nothing else. So I don't know that, again, it just seems a little odd, maybe. And also there's court orders in place, but then maybe they exceed the scope of the court order. But, this is not meant to deal with the battery issues. That's another cause of action. So I could see the Court of Appeals potentially limiting or reducing that amount down. So I think that that's a potentially viable note, and I take note of that. What is the reasonable value or expense of hospitalization to be obtained after she reaches the age of 18 from the false imprisonment? $325,000. This amount almost seems like unduly low in by comparison, again, to the other numbers, because it just seems a little odd. But additor, which is the reverse of remittitor, right? Adding to it, like I don't think I think that the judge will keep that, and the Court of Appeals will keep that. I don't think they'll add to it, so I don't think there's any problem with that. And under the circumstances, clear and convincing for punitives, again, that's fine. And then as a result of all that stuff combined, they find punitives in the nature of $10 million, which seems perfectly reasonable for punitives for all that stuff combined. It's well within the monetary caps or any concerns thereof. It's well within any sort of Supreme Court guidance, so I don't see any particular problems. So the only real problem I potentially have is for the $15 million number, because I'm not sure it belongs in that space. So I could see it being reduced, but it's an avenue of attack. All right. Claim 2 for battery on January 6th. Okay, so now this is for the period of holding her down while we're taking pictures and stripping her and removing her clothing, right? That's all battery. You know, when you touch the clothing of a person, right? If you touch the clothing of the person that they're wearing that clothing, that's battery, right? So that's because it's an object that's close enoughly associated with the person. So it's like, oh, I only touched their shirt. Yeah, but you know, the shirt was attached to the person at the time, so that counts as battery. Plus they're removing the clothing, plus they're touching her, whether they're holding her down, you know, they're touching her, and that's a battery if it's an unwelcome touching. So, you know, whether they're holding her down is slightly immaterial, I suppose, except insofar as it goes to damages. But there's enough information from which a jury could conclude they were holding her down. So either way, we are obviously going to interpret the verdict in the light most favorable to the jury. So anything that will support it. So they held her down, they stripped her clothes off, all that stuff. So that's fine. Was the total amount of damages for psychological treatment to be incurred in the future after she reaches 18 based on the battery itself $4 million? You know, that seems reasonable because, again, that would be the kind of thing that would, you know, resonate with you, being, you know, stripped down and held down and have your photographs taken against your will. I would imagine that that could reasonably impact someone's mind in the future. So, you know, $4 million for that seems pretty reasonable. Was the total amount of damages for pain and suffering, disability, physical impairment, which we say twice, I take note. So there's a typo in the instruction because we asked the same thing twice. So did the jury award the same thing twice, or did they, because you basically explicitly asked them to double damages, because you can't award damages for the same thing twice. Right. So but the thing literally says physical impairment twice on the form. So there's an appeal issue for you. Mental anguish, inconvenience, loss of capacity for life of enjoyment, sustained in the past and to be sustained in the future for the battery occurring. $8 million. Yeah. I mean, again, that is probably sustainable because we're not just talking about, you know, mental counseling, because that's more in the nature of 17. But in the nature of 18, we're talking more about the mental anguish and the pain of that and the suffering that she'll result of that. So she'll need $4 million in counseling to deal with $8 million of pain and suffering. So I think that amount is probably sustainable. The Court of Appeals might potentially reduce it, but I don't think it's so outrageous that the Court of Appeals is going to go out of their way. So I could see this being a potential line of argument, but I think it's probably a somewhat reasonable calculation. Someone in chat says, loss of capacity for enjoyment in life. How do you put a price on that? Well, the jury did. So, okay. So that's the number. Okay. The defense attorneys not review the jury instructions. All I'm noticing is that there's an error. All I'm noting is that there's a mistake. So did they review the forms? Probably. Is there a mistake in the question? Yes. Is there a typo in the answer? Yes. Is it potential grounds for an appeal? Of course. I'm simply noting potential grounds. I'm just trying to show you potential problems. Was a reasonable amount of hospitalization occurred by Jack for his child in the past or to be obtained? $559,000. Okay. Probably. I think it's probably okay. And then we find punitives, which we awarded, I think, $15 million in punitives for this battery. So that seems probably pretty likely, I think, to be sustained. Again, we've talked about $12 million in underlying compensation, $15 million in punitives. Even if we were to reduce the compensatory damages down, because we would still be within a 3x multiplier as long as we were at 5 million. And as many of you've noted, because we found intentionality, we can probably blow through the caps anyway. So even if we reduce this $8 million number down, I think the punitives are probably safe, because it's a reasonable calculation even on a corrected compensatory. So even if we played with these numbers a little on appeal, it's fairly marginal. I mean, it's, let's call it $4 million that Johns Hopkins gets back in rebate. Ooh, right? So, and that's, being very generous about the whole thing. So it's an avenue of attack, but I don't know about that. All right. Now, this one's pretty interesting for me. This is battery for hugs, pats, kisses, and placing on the lap for Maya Kowalski. Did Catherine Beatty commit one or more batteries through hugging, patting, kissing, and placing Maya on her lap? Yes. All right. So that seems, these numbers seem a little excessive for that. I mean, it's not something she wanted, but, is it worth the kind of numbers we're talking about? And I'm a little dubious on that. So I simply note it as a potential issue, that the number seems a little disconnected from the question. What is the total amount of Maya Kowalski's damage for psychological treatment incurred in the future after she reaches 18, based on Catherine Beatty hugging, patting, kissing, and placing Maya Kowalski on her lap? $8 million for that? I mean, first of all, I simply note, first of all, that that's a lot of psychological treatment. And I also, in combination with the other psychological treatment numbers, the total number of all psychological treatment does strike me as a little high. I mean, how much psychological treatment can one person get? I suppose. It seems like a lot, but okay. What's the total amount of Maya Kowalski's damages for pain and suffering, disability, physical impairment, which apparently, again, we said twice, so please note that as a typo, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future, based on Catherine Beatty's hugging, patting, kissing, and placing Maya Kowalski on her lap? $11 million. This amount seems high to me, because at least as far as this question is concerned, we're not talking about a assaultive act, if you understand my meaning. Right? I know Maya Kowalski just went to the sheriff's office to say that she was assaulted in a criminal sense, in a prurient criminal sense, which, okay, but that isn't what this is for. This is for, things that it seems like $11 million. I mean, again, it's not something she wanted, but is it worth $11 million? Again, I could see the Court of Appeals potentially reducing that amount down, because I'm not sure that amount is really a sustainable amount for the battery that occurred as a result of hugging, patting, kissing, and placing Maya Kowalski on her lap. It strikes me as a little high. And so I think, and remember, this is not meant to punish. We already awarded punitives, or we're going to award punitives in a separate section. This is just to compensate, right? This is just to compensate, not to punish. So I think $11 million seems a little high for that. I mean, $11 million, that's a lot. But maybe that's just me. What's the reasonable amount of expense or hospitalization incurred by Jack Kowalski in the past or to be obtained in the future until he reaches 18 based on this? $1,000. So she only needs $1,000 of treatment until she reaches age 18 for all the things that have happened, but she needs $8 million in the future. Okay. Solo Yellow says CRPS has to be factored in. Not well, maybe. If you believed that she incurred physical pain as a result of, so CRPS, as I understand it, is a condition that can come and go, and where you have long periods of good days and sometimes short periods of bad days. So if you believe that at the time that she was experiencing a lot of pain from these touches, then okay. But that wasn't really what I understood the facts to be, but maybe I'm misunderstanding the facts. So if you believe that she was experiencing CRPS and these touches were particularly painful at the time, these numbers become a lot more justifiable. Darcy says, I think you're looking at legally and not from a normal juror's eyes. Well, yes, I am. But then again, as I expressed, the jury is obligated to look at it through the legal lens. The jury is required to obey the court's instructions. The jury's power is to find facts, but they must, when doing so, find the facts in accordance with the law as the judge tells them. So the jury has to award damages based on the question they're asked and nothing more. And if the jury didn't do that, the jury is in violation of its oath and has exceeded its role. And the Court of Appeals must reverse, or at least remit the damages down, because the jury didn't do what they're supposed to. The jury is obligated and required to follow the court's instructions. They're obligated and required to answer the question posed and nothing more. So if the jury didn't do that, the jury was wrong, because the jury swore an oath to follow the court's instructions and obey the court's instructions and to follow the court's instructions. And if they didn't do that, they're wrong. So that's all I have really to say about that. Can a spouse of a juror be in the courtroom as their spouse is on the jury? Sure. That's fine. It's a public courtroom. That's not a problem. Sure, there's no problem with the spouse of a juror being in the courtroom as their spouse is on the jury. That's in the absence of some specific, in general, I mean, if a court has some sort of specific order for some sort of specific reason, maybe there's some case somewhere where that doesn't make sense. But for the vast majority of the situation, sure, it's a public courtroom. Anyone can come. The only people that can't be there in the courtroom are the witnesses, because they're sequestered. They're kept out from each other. But anyone else can be in the courtroom. It's fine. Ongoing damages must include factors that aggravate and influence future instances of CRPS and treatment thereof. To the extent you think that, to the extent that you think that because remember, we gotta focus on the question. But to the extent that you think Maya Kowalski's CRPS will be aggravated in the future because of Catherine Beatty's hugging, patting, kissing, and placing her on her lap, then sure, you should award damages for that. But I don't really think that's the case based on my understanding. I don't really think that Maya Kowalski's CRPS is being aggravated because of that. So yes, you would factor in if her putting her on her lap and patting, kissing, and placing her aggravates her CRPS, or in and of itself otherwise would cause our CRPS to be worse in the future, then yes, you would properly compensate for that. I'm just not sure the facts support that. I think the jury brought punitives included in the first phase. Do you know if the jury is asked to bring punitives in? It doesn't really matter either, or advise that there's punitive phase. It doesn't matter either way, because the jury is obligated to follow the instructions of the court. So regardless of whether we tell them, we don't tell them there's a punitive phase probably, but either way, it doesn't really matter whether we tell the jury there's a punitive phase or not, because the jury's decision should be exactly the same either way, because the jury is supposed to do exactly what the court orders them to do. That's the nature of the instructions. So the jury is only supposed to compensate. So whether or not there's a punitive phase or not is irrelevant. Legally, it's legally irrelevant, because the jury isn't supposed to find punitives right now, although they were asked about punitives for some of them in the form. So they were advised there was a punitive phase, because they said, do you think we should find punitives? But they're only meant to compensate. I suppose someone could raise an objection to the form on appeal on the basis that by asking, I suppose someone could raise an issue on appeal by asking, actually by telling the jury there's a punitive phase, that they thought they were supposed to award punitives now. Because like for question 20, under the circumstances of this case, state whether you find by clear and convincing evidence that punitive damages are warranted for the battery occurring, and they say yes. So there's a potential issue for appeal. Maybe the jury thought they were supposed to award punitives as part of this because they were confused by question 20. Maybe advising the jury there was a punitive phase was actually a mistake, because they thought they were supposed to put punitives in. So yeah, there's an issue on appeal, as we're looking for issues on appeal. So that's a good note. All right, claim 3, medical negligence. All right, I have some issues with this for a lot of legal reasons. First of all, Dr. Sally Smith being an apparent agent of Johns Hopkins, I think is a bit of a stretch, but perhaps, so we'll just assume that the jury can find that for the sake of argument for the moment. But I think, that she's an apparent agent with respect to medical treatment is a little challenging, but okay. And then they say, was Dr. Sally Smith negligent in the medical care of Maya Kowalski? I don't know, because I don't really know what she did in this with specific request to the medical care of Maya Kowalski, right? So what did she do in terms of medical care is a little bit unclear. So I think that's challengeable. Then they say, excluding and not considering the conduct of Dr. Sally Smith, were one or more other hospital providers negligent in the care? And was their negligence a legal loss of injury or damage? I think it's a little bit problematic as well, too, because the problem is CRPS is a diagnosis by exclusion, and also that it's also a diagnosis that is not particularly well understood, and the hospital only has to provide the ordinary standard of care, right? They don't have to provide some extraordinary standard of care. So I think finding medical malpractice here is a little challenging under the law, because I think the hospital, at least in the first instance, had every reason to be skeptical of Maya's treatment by other doctors, because some of her other treatments on paper look insane, right? As the hospital noted, and I think quite rightly, right, the amounts of ketamine that Maya Kowalski was being given look crazy, certifiably nuts. So I think a reasonably prudent doctor applying the ordinary standard of care could look at the history of Maya Kowalski's treatment and say, this treatment is crazy. It's cuckoo for Cocoa Puffs level of batshit nuts. So I think a reasonable doctor applying the ordinary standard of care could look at this data and say to themselves, okay, these other doctors are basically using Maya as some sort of guinea pig, and or they're quacks, and or they're trying to prove their pet theory, and or fill in the blank otherwise. And Maya Kowalski's been getting some really, really batshit crazy treatments by some snake oil, quacks. So I'm a little bit sympathetic, maybe, than some of you guys to this, because I think the reasonably prudent doctor could look at this and be like, this doesn't make any sense, and something is wrong in the state of Denmark. Now, whether or not they should go after the doctors who did that, first of all, Johns Hopkins doesn't have any particular power to go after them. Second of all, some of them aren't even in this country, so that makes it more difficult. Third of all, even if they should go after the doctors who prescribe the treatment in some sense, their more immediate obligation is to the patient, because that's their first priority. Obviously, their first priority isn't to deal with the other doctors who are quacks, right? Their first priority is to deal with the patient in front of them. So even assuming that Johns Hopkins should have, filed complaints with various medical ethics boards or whatever, their more immediate obligation is to take care of the patient in front of them, and to do so within the best standard of care that they can. So particularly because CRPS is not a well-known disease, and particularly because it's a disease of exclusion, and particularly because it's super duper rare, it's like that old saying of doctors, when you hear the clip clop noise, think horse, not zebra. Right? The overwhelming odds are that it's a horse, not a zebra. And so it's like, so if the hospital thought to themselves, okay, I hear hoof noises, it's probably a horse, and these other treatments look like zebras to me. That's certainly a very reasonable conclusion. So I'm a little bit more sympathetic. I'm a little bit more sympathetic to this under the medical malpractice cause of action. So I'm not really sure that there's medical malpractice here. And Rob also, incidentally, last night indicated similar doubts for at least comparable reasons. Rob's analysis is different than mine. We are approaching the problem differently, but we have similar skepticisms. So at least two lawyers look at this and are like, eh. So we're having some doubts here. So whether she's an apparent agent is questionable. Whether or not there's medical negligence is questionable at best. So what is the total amount of Now, this is not the most problematic cause of action, of course. The most problematic cause of action is the intentional infliction. We'll get there in a minute. But I simply note that this action is viable. There's a viable line of attack on appeal. That is what I'm here to note. So what is the total amount of damage for lost earnings in the past, lost earnings in the future, medical, psychological, nursing care? $4.7 million. From the medical negligence? Okay. I don't know. But all right. So presumably we're saying implicitly that Maya Kowalski's CRPS will be worse because of what Johns Hopkins did, to the tune of $4.7 million. Which I don't know if that's really based on the facts. I suppose it doesn't necessarily have to just be CRPS, incidentally. It could be other medical things as a result of the negligence, but I don't know. And then $22 million for pain and suffering, disability or physical impairment, mental anguish, inconvenience, aggravation of disease, or physical defect, and loss of enjoyment. $22 million. I have some doubts there, to be sure. Excuse me a second. I'm about to choke. One moment, please. All better. All right. So I have some doubts as to this number as well. I have doubts on this cause of action. I have doubts on this number. Okay. Fraudulent billing. Did they fraudulently misrepresent a matter on their invoices? I think finding yes is viable. Did Jack Kowalski or his insurance company rely on their detriment? I think saying yes is viable. All right, then these numbers seem a little bit problematic to me, right? All right, presumably the fraud, assuming you believe the fraud occurred, the fraud by its nature in compensation can't have resulted really in any more damages than the bill itself, right? Because that would be the amount, right? We falsely billed you for $500,000. So the total amount of compensation would be $500,000, because assuming the entire bill is fraudulent, which I think is a bit of a stretch, but I digress. But even assuming it is, like, the total amount of compensation is $500,000. So in 32, when they say, what is the total amount of Jack's damages for any deductibles or co-pays incurred as a result of my Kowalski sheltering at Johns Hopkins, and again, a little typo there. And also, as a result of the sheltering, there was a court order at the time. So, there's that. So there's that problem. Or increases in the insurance cost in the past or in the future, including higher premiums, co-pays, and higher deductibles. $3 million. So we think the amount of additional insurance that Maya will need, not just insurance, but additional insurance, is $3 million. That's a lot of medical insurance. And thanks to Obamacare and the Affordable Care Act, anyone can get insurance these days. No preconditions, right? So, I don't know about that. 33 says, what's the total amount of damages for difficulty finding insurance? $2 million. So apparently it's going to take $2 million worth of time, I guess, to find additional insurance. So assuming $20 an hour, that's what, 10,000 hours of additional time to find insurance. I don't know about that. So I have some issues with those numbers as well. All right, then we get into the intentional infliction of emotional distress claims, where things get a little bit problematic. Now, 5 is not problematic, though. It's more 6, right? Because in 5, we're dealing with the damage to Maya's mother prior to her death on the 7th. And I think saying $3 million here is easily sustainable, right? Because the hospital, through its actions, again, I have some doubts myself as to whether or not there was really stuff targeted to Maya, misspoke, targeted to Maya's mother. But even though I have some doubts, first of all, I'm not sure I disagree with the jury's verdict in the first instance. Second of all, even if I did, I can't reverse as a court of appeals, because that's not my role. My role is only to find that it's not legally sustainable on the court of appeals level, and I think it's legally sustainable, right? So even if I disagreed with it, which I'm not sure I did, I couldn't do anything about it anyway. She has pre-existing conditions. I think her insurance premiums would be pretty high. I don't think you're allowed to take pre-existing conditions into consideration anymore. That was one of the things of the Affordable Care Act, right? The insurance is the same, I think, regardless of pre-existing conditions. And even if it's not that much an increase, but I could be mistaken. So I think this amount is probably fine. So I don't have a particular problem with that. 6 is where we have problems, because we've discussed this many times, right? We have a problem because self-deletion is normally thought to be an intentional intervening act that breaks the chain of causation. And here we're trying to kind of ignore that. And I think that opens up a lot of very uncomfortable possibilities in the future. So we've discussed this at length. I don't have to beat a dead horse. I just simply note that, as Rob has said, as I believe Peter has said the same thing, although I think he disagrees about the probability of the Court of Appeals doing something about it. But I think he also highlights this as a problem. Like every lawyer highlights this as a problem, right? We have disagreements about its tenability, which is fine because it's a somewhat novel cause of action. So the fact that the lawyers are disagreeing a little bit on this is perhaps even more understandable here than in normal, because we don't have enough background data from which to draw a more concrete inference, right? We're all kind of guessing a little bit more in a legal dark zone. So the fact that there's some disagreement is very normal to me, because we're all guessing on probabilities, and we're all guessing also based on what we perceive as being the overall direction of the courts in causes of action that could be thought as being in some sense comparable to this. So we are looking at, for example, criminal cases, like, for example, the one out of Massachusetts dealing with the manslaughter count, although that case was also controversial in its own times for very similar reasons. And the courts ultimately upheld that verdict, which, fair enough. But that was in no sense, I think, necessarily obvious. And also in some of the criminal contexts, some of this has been remediated by statute because the legislatures rather, have made it more easy to find harassment and find cyber harassment. And there's been additional laws passed in that domain. But this is being done by the court as a matter of common law. And they're trying to basically say what was perceived to be an intervening act that would break causation no longer breaks causation. That seems a bit problematic for a lot of reasons. We don't have to go into depth about that, but I think the probability this winds up at the Florida Supreme Court is roughly 99%. And what the Florida Supreme Court will do about it, my guess, and it's a bit of a guess, is that they reverse. Because I think affirming raises too many problems without the legislature's, action. I think the probability is they reverse, but who knows, right? We're all guessing in the dark about what the Florida Supreme Court is going to do 3 or 4 years from now. So, yeah. So also, as to uncontrollable impulse on 37, I have problems with this as a matter of fact, right? I don't think there's an uncontrollable impulse. To my mind, the facts do not support uncontrollable impulse. The manner of death requires too much deliberation for incontrollable impulse. Also, she left a note, which also I don't think shows uncontrollable impulse. That she literally couldn't have done anything else. It seems a little bit implausible to me. So I think 37 is not sustainable as a matter of fact. I'm not sure any reasonable jury could find 37 as a matter of fact. So that's sort of what I think. Creed asks, Appellate IID question. If you have two causes of harm in IID, and one is immune from statute, is the other on the hook for the harm caused? Yeah. Yeah. Assuming that you find that they are both causes, then yes, if one of them is immune, the other would bear the whole burden of the thing. That sucks. But that's the law. Yeah. So I'm not sure about uncontrollable impulse because the manner of death plus the note plus other factors doesn't seem to really lend itself. So I'm not sure that's a findable conclusion. And then 38, we have this question about whether it's a substantial factor in the death, which I'm not even sure 100% what that means, to be honest. And yeah, so it's not, I'm not sure substantial factor is the right thing either. You know, whether it would be as opposed to being like the dominant factor or the even sole factor, right? They didn't ask, is it the sole factor? They didn't ask, is it the dominant factor? They asked, is it a substantial factor? Which presumably could be less than 50% and still be substantial, right? 20% is presumably substantial. So even if they're only a 20% cause, I don't know, man. Right? If we were looking at a murder statute, then okay, but we're not. We're in a civil context, and we're trying to take concepts that apply in other domains and apply them in this domain. And I'm a bit skeptical of this whole thing. Yeah. So they find, and also obviously this is the most important for Johns Hopkins because these are all like really big numbers. What's the total amount of damages sustained by the estate? $653,000. That's perfectly fine there. What's the amount of damage sustained by Jack for loss of support and services and funeral expenses? $18 million. What's the total amount of damage sustained by Jack for loss of companionship and protection and for pain and suffering? $50 million. I mean, maybe those are some big numbers, but maybe. I mean, you know, I've never had a spouse die, but I think it would fuck me up pretty hard. So maybe, but whether Johns Hopkins is legally on the hook for this is still very much in the air. What's the total amount of damage sustained by Maya for loss of support and services? $2 million. Okay. What's the total amount of damage sustained by Maya for loss of parental companionship? $18 million. It's interesting, those two numbers. I'm not sure what it says about anything. I just note the interesting aspect of it. You know, Jack is obviously older, and Jack obviously was married to her, versus Maya, who's younger and was the daughter. And we award Jack $50 million and Maya $18 million. So presumably, if you do the math on that, I guess being the daughter is what, like 6 times less important than being the spouse by math? Probably even worse than that, actually, because Jack probably, you know, well, Jack has been suffering it arguably for 8 years. Jack arguably doesn't have that many years to live, and Maya has a lot more years to live. So how many more years will this influence Maya versus Jack? Like 4-1, maybe. And then we deal with the fact that, you know, on the fact that it is the daughter rather than the spouse to get to 18 million. I simply note that the interest, yeah, the fact that a daughter is obviously apparently significantly less important than being the spouse. So losing your mother is nowhere near as bad as losing your wife, I guess. I mean, that's one way to read those numbers. What is the total amount of damages sustained by Kowalski? $2 million. What's the total amount sustained by Kowalski for loss of companionship? $18 million. So I guess it hurts them exactly the same, even though they're not exactly the same age. Lol. So I note the slight disparity there, but okay. All right, then intentional infliction of emotional distress to Maya Kowalski, $3 million. No problem there. No problem there. Right? Did they engage in extreme and outrageous conduct to Maya? Yeah, I think so. $3 million. I have no problem with that to be incurred in the future. They note here, of course, they're not supposed to duplicate damages. So this is $3 million in intentional infliction beyond the false imprisonment and the battery, which I think that's fine. I have no particular problem with that. And then they say, what's the total amount for pain and suffering, aggravation, and loss of capacity for that? $7.5 million, signed by Paul. So some of this is obviously readily attackable. And there's also the issue by asking punitives. There's also this issue by asking about punitives in this form. Maybe the jury improperly rolled in punitives. But, so there's some possibilities there, I guess. So, yeah. Let me just check something real fast. All right. Okay, so I think that will cover everything we need to cover for now. So I just wanted to look at this in a little bit more legal precision. What do I think the appellate court will find? Well, I don't know what they'll find. I mean, I just am sort of highlighting some potential issues, which is all I can really fundamentally do, is highlight some potential issues. My bet, and it's by no means a sure thing, but I think on balance, the Court of Appeals is likely to find count 6 not to be viable. I don't think it's a slam dunk by any means. The courts as a general whole, and it's hard to summarize over 50 states, but I think as a general whole, they're heading more in this direction than not. So the momentum of the court's collective wisdom on cause of action that could be thought of as comparable to 6 seems to favor 6. Nevertheless, despite that momentum, I don't think the court is there at this time. That's just a best guess. So I think on balance, they're not likely to find 6. Also because I think it raises too many problems and raises problems in directions that create real issues. So I think that that's on balance. So I think, yeah. So, and I think some of these amounts might be lowerable, but probably not the punitives. The punitives, I think, are safe, kind of no matter what happens. Because the punitives, even if you reduce some of these numbers, unless you kill the cause of action completely, which would necessarily kill their corresponding punitives. But even if you reduce some of these numbers, the punitives are within sort of any sort of calculation you like. Don't think I'm taking inflation into account. Yeah, she could be in a nursing home for 20 years. Maybe, but as a result of what Johns Hopkins did, as opposed to her underlying condition, I'm less sure. See, Johns Hopkins can only be responsible for what it did. So will Maya need to be in a nursing home for 20 years? Maybe. But is that as a result of what Johns Hopkins did as opposed to her underlying condition? I'm much less sure. So the question would be how much Johns Hopkins aggravated the problem. They're not responsible for the underlying problem, only their contribution to the problem. So is finding Dr. Sally Smith negligent essentially arguing men mal? Yes. Could the PTSD be a cause of her condition of flare? Physically? No. Mentally? Yeah, quite possibly. Which, yes, but then you have to sever that out, of course. But sure. Could I look at Florida free kill law sometime? What is a Florida free kill law? Let me see if I can find out. I'm interested. You caught my attention. Florida free kill law. What is that? The state statute sometimes to have free kill past the 90s and says when it comes to medical negligence, only a decedent's surviving spouse or a minor child until 25 can pursue pain and suffering damages. That seems like logical. Let's see. Let me maybe read some article about it. Maybe I'm misunderstanding what it is. If someone 25 or older dies due to medical malpractice in Florida, only a spouse or child under the age of 25 can sue for pain and suffering. Interesting. So if you're unmarried, no one can sue for med mal. Your estate can't sue for med mal? That's interesting. So the estate can't sue for med mal. The person themselves can't sue for med mal? That's really interesting. Oh, for pain and suffering. Oh, not for only for pain and suffering. Oh, okay. Oh, but not for the underlying med mal. Let's read this real fast. All potential beneficiaries of wrongful death, including decedent's estate, shall be identified in their complaint. Each survivor may recover the loss of services and supports from date of injury to death with interest and future support. Okay. The surviving spouse may also recover for loss of companionship and protection. Minor children of the decedent, all children of the decedent, if there's no surviving spouse, may recover for loss of parental companionship. Each parent of a deceased minor child may also recover from mental pain and suffering. Wait, what am I misreading? Section 8. The damages specified in subsection 3 shall not be recoverable by an adult child, and with damages specified in subsection 4 shall not be recoverable by parents of an adult child with respect to medical negligence as defined in this subsection. So you can't recover for pain and suffering for the only the spouse or child can sue for pain and suffering. Interesting. Okay. (1601) subsection 1. Interesting. Yeah, I've never heard of that before. So you can't sue for pain and suffering. You can sue for the damage, but not for pain and suffering, unless you're. So only, yeah. Okay. All right, that's an interesting way of going about it. So parents can't sue for their adult children dying? No, that's not quite what it says. It says it just can't sue for pain and suffering, if I'm reading this correctly. Yeah. Yeah. So if you go back to, I think it's only for pain and suffering. Because if you go back to subsection 8, which this article refers me to, right? It says the sub 768.21 subsection 8, and you go to subsection 8, it says the damages specified in subsection 3 shall not be recoverable by adult children, and damages specified in subsection 4 shall not be recoverable by parents of adult child with respect to medical negligence. So you can't recover for parental consent, instruction, and guidance, which makes sense at that point because you're an adult, right? So it's like, that kind of makes sense. And then in subsection 4, you can't sue for mental pain and suffering, but you can sue for the underlying medical harm for the estate. So it's not quite, yeah, I don't think this is quite right. State law essentially banned her from seeking justice over her father's wrongful death. I don't think that's quite right. Maybe I'm misreading it, but that doesn't sound quite right. Okay, yeah, maybe I'm misreading it, but that doesn't sound quite right. Yeah, so they can sue for the med mal. They can sue for damage to the person. The estate can sue for damage to the person. It's just that their children can't sue for damages to them. So, yeah. But apparently Florida is unique in that respect. So that's an interesting thing. But apparently Florida is unique in that respect. So, okay. Yeah. All right. I'm going to sign off for now, guys. I hope you've enjoyed this little walkthrough through some of the details. It's a very interesting case, to be sure. And I understand why passions are high. But, in order to make sure that we're truly getting justice for Maya instead of just vengeance, then we need to look at this with a little bit more care and caution, and also look to the law. So I think the jury in many parts is quite reasonable. And some of the parts might be a little bit unreasonable on some of the edges. And some of these causes of actions may not survive the day. I think the punitives are probably fine. The punitives didn't go for IIAD anyway. So I think the punitives are probably safe. So I think Johns Hopkins is going to have to pay out some serious money, unless they can find flaws like some of the issues I found. But so they might be able to escape some of this, but I wouldn't. I think that I'll say this for sure as well. Thank God the judge broke everything out the way they did, because it makes the Court of Appeals life so much easier. Because everything is segmented out the way it is, and they asked so many specific questions as opposed to just give us a big fat number. It makes the Court of Appeals life so much easier. So now we can actually, if we're going to, instead of just giving a big fat number and we're not sure what for what, now we know exactly for what. So if we need to play around with this, even if we need to kill an entire cause of action, we can do that much easier on appeal. And the odds of having to do a retrial are diminished. They're not zero, but they're diminished because the Court of Appeals has a lot more information than they might otherwise. So they have a lot more flexibility to do things without sending it back, because we don't know what the jury would have done. Yes, you do, because you asked them in so much detail, right? So the probability of having to do a retrial is diminished. So that's nice. All right, I'm going to sign off for now. I hope you've had a great day. I've been on Civil Law. Until later, my friends, I hope all's well. Cheers, my friends, and goodbye.